Never. It's never appropriate for a judge to impose that judge's personal convictions, whether they derive from faith or anywhere else, on the law. If you're asking whether I take my faith seriously and I'm a faithful Catholic, I am, although I would stress that my personal church affiliation or my religious belief would not bear on the discharge of my duties as a judge. As a judge, I would decide cases according to the rule of law, beginning to end, and in the rare circumstance that might ever arise, I can't imagine one sitting here now, where I felt that I had some conscientious objection to the law, I would recuse. I would never impose my own personal convictions upon the law.
We shouldn't be putting people on the court that share our policy preferences. We should be putting people on the court who want to apply the Constitution.
I gather that there have been 6 in the 20th century and 11 if you go back to the Civil War of confirmations that happened during presidential election years. But I think the question is, what does this precedent establish? And I don't think it establishes a rule for either side in the debate. It shouldn't be a surprise that the Senate is willing to push a president's nominees through in an election year when they share the same political affiliation. The one exception to that was Anthony Kennedy, and the one that was confirmed in a period of divided government before that was in the 1880s. Kennedy is a moderate Republican, and he replaced a moderate Republican, Powell. We're talking about Justice Scalia, the staunchest conservative on the court, and we're talking about him being replaced by someone who could dramatically flip the balance of power on the court. It's not a lateral move. The president has the power to nominate, and the Senate has the power to act or not, and I don't think either one of them can claim that there's a rule governing one way or the other.
I don't think the core case, the Roe's core holding that women have a right to an abortion, I don't think that would change. But I think the question of whether people can get very late-term abortions, how many restrictions can be put on clinics, I think that would change.
I would apply Roe and its progeny just like I would apply all Supreme Court precedent.
I clerked for Justice Scalia more than 20 years ago, but the lessons I learned still resonate. His judicial philosophy is mine too. A judge must apply the law as written. Judges are not policymakers, and they must be resolute in setting aside any policy views they might hold. I would discharge the judicial oath, which requires me to administer justice without respect to persons, do equal right to the poor and rich, and faithfully and impartially discharge my duties under the United States Constitution.